We advocate for the taping of custodial interrogations. That is, from the time someone's given a Miranda warning, or really should be given a Miranda warning, you have the right to remain silent. The interview should be taped. And that way, at the end of the session, if someone confesses, you have a complete and accurate record of what went on in the room. We think for the over 500 jurisdictions across the country who have adopted this procedure, it's very, very helpful. Prosecutors like it because when they're facing challenges in court that the confession was coerced out of them, there's an absolute record of what happened. It also, I think that there's often inadvertent leading by the questioner in the interrogation room, where they know what the right details are, they're getting information from somebody, and they're beginning, after hours and hours sometimes, to feed details to them, inadvertently, things that only the real perpetrator could know. If you have the record, you know how it happened, who initiated the fact that there was a yellow dress, who initiated the fact where something was found, and who didn't. And I think it's helpful for prosecutors in assessing the reliability of a confession to be able to have that, and it's certainly helpful for a judge and jury, or jury trying to figure out how coercive the confession was to have a recording. New York does not have a recording of custodial interrogations as a state law, and we think they should. You'll be glad to know that there is recording of interrogations in Oneida County, so your county is ahead of the state on that one. And I will just take a slight digression just to say that I sat on the panel this morning with Scott McNamara, who is your local district attorney, who we have a case now with Oneida County. And I will say that we sent a letter and asked to do a second round of testing. 10 years ago, we'd asked for a first round. It was inconclusive. The county was cooperative then, sort of uniquely cooperative, just very open, very honest, very willing to check it out and figure out if an injustice had been done or not. Mr. McNamara's office was equally cooperative when we approached them again, now that the DNA technology is more sensitive and may be able to get a reading that we couldn't get almost 10 years ago. So just an applause to him for his willingness to find truth in these cases. And he does record interrogations, and we think that they should be recorded across the state. Requiring that only valid and reliable science be used in courtrooms. There are still all sorts of disciplines, and people get up on the stand and testify in criminal cases that really have no valid validation testing. Bite mark evidence is one of those issues. There are all kinds of other disciplines, dog sniffing, footprints, things where scientists stand up, and people who stand up and say they're a scientist, they're a forensic scientist, have an enormous amount of credibility with juries. And we really think that it's hard in the courtroom for people to figure out whether or not there's anything useful about the science that's been presented. And we think that there should be a lot of vetting of those disciplines before they're allowed to be used in criminal courts. The National Academy of Science in Washington is looking at this question right now. They're going to issue a report this summer, and we hope it will be helpful in shoring up better science used in criminal courts. We think that there should be mechanisms, audit mechanisms, independent mechanisms for looking at crime scene problems or crime evidence problems when they occur. So in Roy's case, when you point out that there have been forensic testimony that is an error in the bite mark area, we think that the New York State should have an independent entity that we could call on to go into that crime, into that lab, into that person's work, and say, let's look at what happened here, and if there's something wrong, let's correct it and make sure it doesn't happen again. Fortunately for that one, we got Congress to agree with us, and at least for state crime labs and local crime labs that receive federal money, there must be an entity that can do an independent audit, and the Coverdell program and the Justice for All Act of 2004 requires that. There should be better funding and oversight of public defenders. one of the surest ways, and this is not the case in Roy's case, he actually had a very dedicated, diligent, intelligent legal team representing him. They just didn't have all the information that one might have wanted. But often, unfortunately, public defenders' offices are underfunded and can't dedicate the time or the resources, can't get experts to look at, to have a counter opinion to what's being presented by the prosecution, and that we really have to improve the quality of criminal defense around the country and public defenders in New York State in particular. Not that there aren't some fabulous, dedicated, hardworking public defenders, and there are many, many of them, and many of the people I work with were public defenders at some point. But they are not well funded, and there are parts of the country where the systems are almost non-existent, and there are big problems across New York State, as the recently filed lawsuit tells you, and Judge Kaye's report also indicates that there's need for shoring up the public defense system in New York State. We believe, and Roy's case is a good example, that criminal defendants, both pre-trial and post-trial, should have the right to ask for third-party DNA testing when they believe they have an alternate suspect that could be identified with DNA, including using the data banks that are available in New York State and most states to run the crime scene profile when it doesn't match them, to see if, in fact, it matches someone who's been convicted of similar crimes. We have a client who was 16 when he was convicted, got out at 32. The DNA had cleared him at the age of 16. This is in New York State in Westchester County. DNA cleared him, and they then said, well, the DNA cleared him and he confessed. They said, well, we have your confession, so the DNA at the crime scene must have been from a consensual boyfriend. No one had heard about the consensual boyfriend. Everybody in the family said she hadn't had a boyfriend, and believed that the evidence, the semen evidence in the rape murder that occurred, must have come from the perpetrator. They didn't deal with it at trial. It wasn't allowed. There wasn't a data bank at the time. His repeated requests for a data bank run took almost 10 years. Until it happened, and then a new district attorney in Westchester County ran the profile, came back to a serial sex offender who confessed to the murder, and Jeffrey Descovich, at the age of 32, was freed in Westchester County. So we think people have a right on a showing that it would really do something in the case, not just to have all crime scene evidence tested all the time and thrown up into the data bank. But if there's a showing, a judge should be able to order it. And right now, there's no law in New York that allows that. And finally, I think there should be an Innocence Commission in the state of New York. They exist in many other parts of the country. A body of people that's exonerees, defense attorneys, prosecutors, judges, police officers, crime lab analysts, general citizens, other people interested in justice in the system, who come together and look at the cases, ask what went wrong, and ask the question, what can we change in the laws and practices in our state to prevent this from happening again? Each of these exonerations, as joyful and amazing as they are, represent a serious problem for the criminal justice system. In each of these cases, an innocent person spends years behind bars for a crime they did not commit, while all too often the real perpetrator remains free, sometimes to commit additional egregious crimes. The wrongfully convicted person is destroyed, as is their family and their community. The victim of the crime has a false sense that justice has been done, and the community has a false sense of security. The only thing more tragic than the wrongful conviction itself is if, as a society, we do nothing to figure out what went wrong and to prevent them from happening again. On this Law Day, I ask you to join with us to help make New York an even more and just and fair state. The people of the state deserve no less. Thank you.